The Latin American University of Foreign Trade, through the subject of Technical English 2, presents Environmental Law, presented by the students of the degree of Political Science and Law, ASTRID Castillo, Bárbara GORRIN, GIBELL GÓMEZ, and Joseph Johnson, presented for the consideration of Professor Fátima Sánchez. Introduction. One of the most outstanding features of Panama is its high biodiversity. A few hectares of tropical forest can host thousands of species of plants, animals, and microorganisms. However, important species of the Panamanian fauna are in danger of extinction, such as the jaguar, harpy eagle, tapir, among others. That is why the law and measures for the protection and conservation of the environment are very important. Historical background. When Panama became independent from Colombia in 1903, there was no law to protect the environment. In fact, until then, neither as a Spanish colony nor as a Department of Colombia, Panama had environmental legislation. Even the Haiguno-Barilla Treaty in 1903, which gave the Panama Canal in perpetuity to the United States, does not mention anywhere, and nor did they think about the ecological, environmental, nor natural resources issue, since at that time these issues there were no of interest to any, since the country had other priorities. In the 1960s, there were few advances regarding environmental legislation. Only articles related to this topic in Chapter 7 called the Economical Regime in Articles 118 to 121 of the National Constitution of 1946, which superficially mentions natural resources, the environment and pollution, and few references in the Sanitary Code of 1947 and the Agrarian Code of 1962. The first step in terms of environmental legislation was taken with Decree number 39 of 1966, by which the forestry legislation of the Republic is issued. However, this decree only mentions aspects of soil and water conservation. It does not mention the environmental or ecological issue. Later, in 1977, with the Torrijos-Carter Treaty, Panama not only took a step to consolidate its sovereignty over the canal, but also advanced in terms of environmental legislation, since this treaty included a title related to the protection of the natural environment. However, this chapter of 3 short articles referred in little detail to a Panama-US mixed commission that will deal with everything related to the Panama Canal and its effect on the environment. In practice, this commission never actually functioned, not even on the important issue of contamination by water materials in some forest areas of the canal, or the contamination of the canal hydrographic basin due to emission residues, oil, and other pollution from the passage of ships. Law 1 of February 3, 1994, by which the forestry legislation is established in the Republic of Panama and other provisions are dictated, creates the National Institute of Renewable Natural Resources in RENARE. Article 7 of this law is reformed shortly after by Law 30 of December 30th, 1994, establishes the obligation for all private, public, or mixed company to present an environmental impact study when these works affect the environment. In July 1998, Law 41, General Environmental Law, was enacted, with which INRENARE became the National Environmental Authority, ANAM, so that through the executive branch it will regulate environmental consultancies, environmental audits, and environmental adaptation and management programs, PAMAs. Later, through Law 8 of 2015, the Ministry of the Environment was created, and certain provisions of the General Law of the Environment and that of the Aquatic Resources Authority of Panama were modified. Law 8 of 2015 established that the Ministry of Environment is a governing entity of the state in matter of protection, conservation, preservation, and restoration of the environment and the sustained use of natural resources to ensure compliance and application of laws, regulations, and the national environmental policy. On the other hand, it is important to highlight that the environmental law is a matter that is in constant evolution to the National Assembly, since there is a specialized commission called the Population, Environment, and Development Commission, which make any legislative initiative its own regarding these environmental and ecological issues. Environmental General Law, Law 41 of 1998. Ministry of Environmental has the following functions: ensure compliance with the law, regulation, environmental quality standards, and the technical and administrative provision assigned by law. Direct, supervise, and implement the environmental policies, plans, strategies, and programs of the state with the collaboration of public and private organizations. Formulate bills for due consideration of the corresponding instances. Promote citizen participation and the application of the law and its regulation in the formulation and execution of environmental policies, strategies, and programs of its competence. Environmental Impact Study Process. Law 1 of February 3, 1994, by which the forestry legislation is established in the Republic of Panama and other provisions are dictated, create the National Institute of Renewable Natural Resources in RENARE, but its Article 7 is reformed by the Law 30 of December 30, 1994, established the obligation for all private, public, and mixed companies to present an environmental study. Then these works affect the environment. In July 1998, Law 41, General Environmental Law, was promulgated. This law eliminated the form in RENARE and created the National Environmental Authority, ANAM, so that to the executive branch it could regulate environmental consultancy, environmental audit, and programs for the adaptation and environment management, PAMAs. environmental supervision, control, and inspection. In reinforcing compliance with regulation and the prosecution of environmental offenders or criminals, it has been seen that the so-called environmental prosecution must have personnel specialized in environmental issues with knowledge of the law and not the other way around, as is the current case of many. The creation of an environmental police helps to strictly comply with this environmental regulation and to prosecute misdemeanors or environmental crime. But it is also necessary that this personnel be trained not only in the rescue of wildlife, but also in law and regulation that govern our country in order to successfully stop offenders. Article 40. The supervision, control, and inspection of the activity works and projects subject to the environmental impact assessment are subject to the presentation of the environmental plan management plan and complied with the regulation environmentals. This is an inherent function of the Ministry of the Environment, which will be exercised together with the competent authority in accordance with the regulation as the case. Article 43. The Ministry of the Environment will coordinate with the competent authority the formulation and execution of the monitoring programs for the quality of the environment and environmental closure plans in order to monitor compliance with the established standards. This regulation will develop the monitoring and control mechanisms within the interinstitutional environmental system referred to in the Article 16 of this law.
Citizen participation in environmental impact studies. The promoter must include the public from the beginning in the decision-making and reviews of the environmental impact study, as well as record all the activities in the study and consult the community in its preparation, as established and to comply with the regulations. Citizen participation plan. During the preparation of the environmental impact studies, the project promoter must prepare a citizen participation plan in accordance with the following contents. Number 1. Incentive for citizen participation during the preparation of the environmental impact study. Number 2. Form of community participation, as well as surveys, interviews, workshops, assemblies, and/or work meetings. Number 3. Information mechanism for the various sectors of the citizenry. Number 4. Request for information and response to the community and, in particular, from the environmental groups and similar organizations. Environmental resolutions. If the environmental impact study complies with the requirements of this regulation, the National Environmental Authority will rate the study favorably and will issue the environmental resolution that approves it. If the resolution is unfavorable, the project or its modification cannot be carried out. The ministries and sectoral bodies with the environmental competence will be obliged to deny the corresponding sectoral permits, even if the other legal requirements are met. The resolution that qualifies the environmental impact study will include at least the following aspects. Number 1. The indication of the elements, documents, legal and regulatory powers that were in view to resolve. Number 2. The technical or other considerations on which the resolution is based. And number 3. The well-founded opinion of the sectoral environmental unit and the reports emanating from other organizations with environmental competence issued during the process. Any environmental resolution that approves or rejects an environmental impact study will be notified personally.
other Panamanian laws.
Law number 1 of February 3, 1994, Forestry Law, established the forest legislation of the Republic of Panama, having among its objectives the protection, conservation, improvement, valorization, education, research, management, and rational use of the forest resources of the Republic. Law number 24 of November 23, 1992, Reforestation Incentive Law. Law 24 established incentive and regulates reforestation activity in the Republic of Panama. Article 6. Declare yourself exempt from the payment of import taxes and other fees. The introduction to the country of machinery and agricultural, forestry, industrial, rolling stock, materials, tools, agrochemicals, forest research equipment, seeds, stakes, and forest plants, and other elements necessary for the use exclusive of the activities of reforestation, management, and or use of the forest plantations. Law number 24 of June 7, 1995, Wildlife. Fishing and hunting of those species that are included in the list of threatened or endangered species is prohibited. Likewise, hunting and fishing are prohibited during closed periods declared by the National Director of Protected Areas and Wildlife. This law established that wildlife is part of the natural heritage of Panama and declares its protection, conservation, restoration, research, management, and development of genetic resources as well as species, rare species and varieties of wildlife for the benefit and safeguard of the natural ecosystems. Resolution Board of Directors 994 of June 29, 1994, which defines 17 categories of management of protected areas in Panama, by means of which the national system of protected wilderness areas is created. The administrative entity of the National Institute of Renewable Natural Resources, and each of its management categories are defined. The Board of Directors of the National Institute of Renewable Natural Resources in use of its legal powers. Considering that in order to conserve and protect an important part of that our natural resources, more than 1 million hectares of the national territory have been declared wild protected areas. Resolution Board of Directors 2292 of September 2, 1992, which establishes the National System of Protected Areas (SINAP). 8. In renew the National System of Protected Wild Areas as an administrative entity in charge of the administration, planning, conservation, surveillance, protection, and control of natural resources renewable.
Thank you for watching.